Good afternoon and welcome to the South Carolina Public Service Commission. It is approximately 2 o'clock on December 11th, 2025. We are here on docket number 2025-230-E, which is a joint application of Duke Energy Carolinas LLC and Duke Energy Progress LLC to engage in a business combination, address regulatory conditions and code of conduct, and request for accounting orders. All commissioners are present here in the hearing room. Ms. Westerhill, would you explain today's proceeding?
Yes, sir, and thank you, Mr. Chairman. The hearing before you today is an oral argument in docket number 2025-230-E concerning the petition to intervene, which was timely filed by Carolinas Transmission Consumer Group on November 12, 2025, pursuant to South Carolina Code Annotated Regulations 103-829 and Commission Order Number 2025-741, dated December 4th, 2025. The Clerk of the Commission scheduled oral argument in this docket to begin today, Thursday, December 11th, 2025 at 2 p.m. or immediately following the Commission business meeting before the Public Service Commission in the hearing room located here on Executive Center Drive in Columbia, South Carolina. Mr. Chairman, upon inquiry of all participating counsel and parties of record, the parties are ready to proceed with oral argument when called.
Thank you very much. First, we'll have the parties introduce themselves, and let's begin with the company.
Good afternoon, Mr. Chair. I'm Sam Wellborn here on behalf of Duke Energy Carolinas and Duke Energy Progress. With me is outside counsel Lyle Trawick.
Thank you very much. And for the intervener, Carolinas Transmission Customer Group.
Good afternoon, Commissioners. Taylor Spear for the Carolinas Transmission Customer Group. I'm joined today virtually by two representatives of my clients. One is Jessica Rosier, as well as Jeff Meredith, who is the General Manager of the Municipal Utility for the City of Greenwood.
Thank you, and welcome to all three of you. The Office of Regulatory Staff.
Thank you, Mr. Chairman, members of the Commission. Ben Muschin on behalf of ORS. With me today also is Jasmine Gunning.
Thank you. I believe we have at least a couple of parties who are appearing virtually. Mr. Gooding, are you here for the SC Coastal Conservation League or?
Afternoon, yes. I am here on behalf of CCL Upstate Forever and Vote Solar. I should mention that CCL et al. Do not plan to participate in the arguments today. And so if the chair would allow, we would appreciate being excused from today's arguments.
Certainly, certainly. And thank you very much. Yeah. As far as Carolinas Clean Energy Business Association, Mr. Witt, I think I saw you on there somewhere.
Yes, Chair Powers, Richard Witt from the Witt Law Firm for SECEBA, and we will not have active comments participation, but we will stay on the hearing for the entire hearing.
Welcome to have you. And the South Carolina Department of Consumer Affairs.
Good afternoon, Mr. Chairman. Roger Hall on behalf of the department.
All right. Thank you very much, Mr. Hall. Is anyone online for Walmart or Ducor Steel? Hearing none, I think that would be Sierra Club. All right, that would be all the parties. Since, Mr. Spear, you are the moving party, you get to go first.
Chair Powers, may it please the Commission. I have the pleasure of representing the 5 electric utilities that have petitioned the Commission to intervene in this proceeding. Each utility is a transmission customer of DEC, and each utility is here representing itself as well as its retail customers, which are 67,000 customers that are located in North and South Carolina. These utilities are joined by a common cause. They seek to intervene before you to educate you and inform you and ask your questions and answer your questions as to what will happen to DEC's customers after these two utilities merge if the commission approves the merger. Duke's testimony and application in this proceeding admits that absent abatement, South Carolina retail rates will rise, at least in the short term. And the reason for this is not complex. If the merger is approved, DEP's high cost or larger cost system will be subsumed into DEC. And what is critical, I think, for you all to understand, there's going to be some points, but this is one of them. That higher cost system represents a burden to DEC. Yet DEP is not being asked to pay for the luxury of being subsumed by DEC. To mitigate this burden, which is not disputed in this proceeding, Duke asks this commission to approve a subsidy. $25 million annually of purported benefits from the merger will be allocated to South Carolina retail customers. $55 million annually will be allocated from the system's wholesale customers to South Carolina retail customers. And that's to mitigate this burden that I've spoken of. And none of this is disputed in the proceeding. What Duke doesn't want you to hear, and what I believe that my customers have a right to tell you, and what I believe that you certainly will be interested in learning about if leave is granted, is that there's another driver of rates for South Carolina retail ratepayers: transmission costs. In the interrelated FERC filing for this merger proceeding, just like Duke has done in this proceeding, it admits that unless something is done by a regulator, transmission rates will rise because of the merger, at least initially. And so just as it does here, Duke presents FERC with a rate mitigation plan for transmission rates specifically. Now, what's important about this is that this all impacts DEC's customers, including all members of my client. Because those transmission rates, which we admit and we concede, this commission does not set. That's the exclusive province of FERC. But this commission does approve bundling those transmission costs and bundling those rates that FERC sets into South Carolina's retail rates. That's what happens. I have a retail rate. A component of that is transmission costs that we all have to pay for. Now, as what we believe is pretext to keep the commission from hearing about these issues, Duke has concocted a legally and practically wrong argument that we do not have standing to raise these issues before this commission. In doing so, Duke asks you to hold that its customers, my clients, who paid for the transmission system, do not have a right to come in here and inform you that our belief is that DEC is going to be getting rid of those assets on bad terms. Duke asks you to hold, in denying the petition to intervene, they ask you to hold that customers of DEC who, as we speak, are relying on Duke's transmission system to deliver retail power to its 67,000 customers located in North and South Carolina, that's happening right now, don't have the right to come in here and tell you commissioners that transmission rates are going to rise unless something happens. Now, if you're asking yourself, this doesn't make sense or it doesn't track, CTCG agrees with you. Those members should have a right to come in here and discuss those issues with you. And it's legally incorrect for Duke to suggest otherwise. I have searched for a merger case pending before this commission or pending before NCUC, and I have not found one opinion which denied the intervention of a petitioner. Not one. And Duke hasn't cited that for you either. Now, I will concede that in and of itself doesn't mean that I'm entitled to what I'm saying that I'm entitled to. But what you also need to know is that in all of those prior merger proceedings, now I'm talking about NCUC before the North Carolina Utilities Commission, and I'm talking about before this commission, there is a long history of permitting wholesale customers of the applicants to intervene. Because Duke has invited it, I would like to share with you the long list of those wholesale customers that have been permitted to intervene. But let me, before I get to that list, I do also want to tell you that after our briefing of these issues, the North Carolina Utilities granted my client's petition to intervene in North Carolina. Duke has moved to reconsider that order. However, there is a live executed order that's been issued pending right now, and it says specifically that my clients have established good standing to intervene in North Carolina. So as to that list of wholesale customers that this commission and North Carolina have previously permitted to intervene, we'll start with South Carolina. We have Central's been permitted to intervene in a merger proceeding. The Electric Cooperatives Association have been permitted to intervene. The City of Orangeburg has been permitted to intervene in a merger proceeding in South Carolina. The South Carolina Electric and Gas Company has been permitted to intervene. And a labor union has been permitted to intervene. And they don't use any of these assets, unlike CTCG. NCUC, the North Carolina Utilities Commission, has allowed the similarly the intervention of the North Carolina Electric Membership Cooperation, Blue Ridge, Haywood, Piedmont, Rutherford, and the City of Fayetteville. The list goes on. And in fact, commissioners, the North Carolina Utility Commission has permitted ORS to intervene in a North Carolina merger proceeding. Of course, there was a sister proceeding in South Carolina. ORS is a statutory intervener in that case, but this stands to show you that it crosses state lines. Now, Chair Powers, would you prefer that I handle any sort of rebuttal commentary presently, or would you like for my colleagues to make their argument first?
I have no problem letting you do it either way that you prefer.
Okay.
And I was thinking, I'm sure there may be some commissioner questions at some point. I'm thinking unless another commissioner thinks otherwise, we could hold questions until we've heard from everyone.
Okay. Then I'll continue for just a few moments, and then I'll save some time for rebuttal if that pleases the commission.
That's fine.
Okay, thank you. So you're going to hear from Duke about why they believe that what I've told you is incorrect. And certainly they have a right to do that, but I want to show you a couple things, and I want you to keep a couple things in mind while I speak. They have alleged, as you know, and if I may have access to the Elmo, please. They have alleged that the Duke utilities have argued, we believe wrongly, that CTCG's members don't have standing to intervene. Now, I want to share with you what that standard is, because when you hear them argue otherwise, you need to understand how broad that standard is. This is an actual, what you're seeing is a quotation from Stoney v. Stoney. That's a South Carolina Court of Appeals case from 2018. There's some history in this case, but this is the last one. As you can see that it actually, in this case, the South Carolina Court of Appeals upheld the lower court's grant of intervention of a person that, quote, moved to intervene to protect his interests in certain real property, business concerns, and debts that person asserted he was owed. This is no different than what CTCG argues in this position. They have an interest in DEC's transmission system. It's a publicly regulated asset, and they believe that it's improper for this commission to allow Duke to dispose of that asset without allowing it to speak on its behalf, on its ratepayers' behalf, and on behalf of all ratepayers in South Carolina. But in any event, you see that the standard is quite liberal, and the only thing that my members need to prove to you to establish standing is that we have a personal stake in the subject matter of a lawsuit. and that we're a real party in interest. You're going to hear Duke argue that, well, Taylor says that his clients have a possessory interest in this proceeding because CTCG are transmission customers of Duke. Now, I think that this is an absolute textbook straw man first-year law school argument. We're not arguing that. That is not what we argue to this commission allows us status to intervene in this proceeding. We don't dispute that FERC has exclusive jurisdiction to set transmission rates. That doesn't impact the standing. Our standing is derivative of the fact that we contract for, use, capitalize DEC's transmission system. So when Duke presents its case to you, I think that you should ask it this question. How is it that a user, consumer of a publicly regulated asset that's worth billions of dollars should not be permitted to come into the regulator, to come into this commission and inform it of what we think was going to happen to that asset in the event that this merger proceeds? I don't think that it can legitimately and in a legally supported way answer that question in the affirmative. It's because we do have standing. And this commission does regulate transmission. It regulates transmission through the statute that is issue that we're all talking about here that authorizes this commission to review mergers. This commission regulates transmission through the Siting Act. This commission regulates some portions of transmission through the Base Load Review Act. And of course, as I've already said, this commission approves, although it doesn't regulate the specific rate or choose the rate, it approves that rate being passed through to South Carolina ratepayers vis-a-vis the bundled rate that we all pay. So it's untrue that this issue of the exclusive province of FERC affecting transmission rates has any bearing on what this commission will decide. And our standing is derivative of something else. Before I conclude, I want to add one more thing, and I ask that you consider this while Duke is arguing. They have said that this is a retail merger case. There's no such thing. This is just a merger. There's no such thing as a federal merger case, a state merger case, a FERC jurisdictional merger case, a South Carolina jurisdictional merger case. It's just a merger. The statute that Duke has moved under does not use that word, and that's because it's not there. In fact, the word that it uses is disposition. That's the title of the statute, disposition of assets. That's what Duke is doing in this proceeding, is what our argument will be, as I've said, is that they're dispossessing themselves of this really valuable asset. We use, we contract to use, we pay for, we capitalize, yet we're being told that we cannot come to this commission and advise it what we think is going to happen with that asset, and advise this commission what we think will happen to South Carolina ratepayers if this merger proceeds. Thank you.
Thank you, Mr. Spear. Who is speaking on behalf of the company?
Thank you, Mr. Chairman. May it please the commission. Good to be with you all today. It's my pleasure to represent the companies in this matter, and we respectfully oppose the petition filed by the Carolinas Transmission Customer Group. I want to start, Commissioner Thomas and Commissioner Britt, I had a professor at Wofford who said answer the mail. That's what we did. We responded to a petition filed by the Carolinas Transmission Customer Group. Now, we found out in response, after we issued our response and objections, that, oh no, we're not seeking associational standing. Well, and I know why, because it's not a real group. It's not a business entity. It's not a legal entity. It's just an ad hoc collective of transmission customers. So we can't lose sight of that. And let's look who those members are. App State, Western Carolina, City of Concord, North Carolina, City of Kings Mountain, North Carolina, and the Greenwood Commissioners of Public Works. They are here to talk about transmission and wholesale issues. Against that backdrop, the question before the commission today is whether an ad hoc collective of transmission customers, 80% of whom are from North Carolina, can intervene in the South Carolina retail merger docket to discuss matter that fall under FERC's exclusive jurisdiction and indeed are pending in a FERC docket into which they've intervened. Respectfully, for the reasons we proffered in our brief and those I'll explain today, the answer to that question is no. And the reason is because the interests identified in the petition are simply insufficient to meet the standard set by this commission either under regulation, its existing precedent, case law, or anything of the sort. Now, we're accused of elevating the standard. Respectfully, we're not. I'll go right to a case that my friend on the other side cited, Preservation Society. Justice James engaged in a constitutional standing inquiry in that case, and it was discussing an underlying administrative matter. So we're not moving the ball. We're not moving the goalpost. We are simply applying the law as it is written by the Supreme Court of South Carolina. But there are a lot of sort of intricacies here in both standing law and Rule 24 that I'm happy to walk through. But I'm going to go back to my law clerk days and tell you, here's the easiest way you can write this order. You can apply your own precedent. Order number 2010-221 applied the Duke Power Company v. South Carolina Public Service Commission case, colloquially known as the Greenwood rate case, from which Greenwood is so desperately trying to run, and held that ratepayers lacked standing, citing that case because the asserted interests were too contingent, hypothetical, and improbable to support standing. This commission has applied that case, applied the ratepayer standing doctrine as articulated by our Supreme Court. And the petitioners here fail under that test. They have no reasonable connection. I hear Mr. Spear repeatedly say that their standing is derivative of something. You know what that means? Connected to. But a mere connection under our plain and clear standing law is insufficient. You have to have a real material interest, and under Rule 24, it's got to be a protectable one. His interest is in transmission issues, and those are live and pending in the FERC. The FERC has exclusive jurisdiction over them, not this commission. And, although he says there's no such thing as these different merger dockets, I think that's an oversimplification. I view this as a Venn diagram. The central relief sought in all three proceedings is a request for approval of a business combination. But any similarity ends there. Each jurisdiction has to make its own inquiry under the governing law. So FERC has to decide it under federal law, under its rules and regulations. North Carolina has to decide it under North Carolina law. And that statute, by the way, looks pretty different than ours. South Carolina, you have to decide it under South Carolina law. So this gross oversimplification of the issue is just being, it's just one merger. Sure, that's the relief sought, but that's not the legal framework that you'll be using to decide it. All three are fundamentally different, and one should not taint the other. Each commission gets its own bite at the apple, its own jurisdiction to decide the matters within it. Next, let's go to Rule 24 and the standing hearing officer directive that was issued at granting SACE and CCL's petition to intervene, unobjected to. Just recently, the commission found, or the standing hearing officer found, that there was no prejudice to the other parties. I want to hit on that here because that has been unrebutted in any filing with the commission. All right? We bear the burden of proof. Proof in our case is not prejudice. The case law is crystal clear on that. You know what is prejudicial, though? Having to call witnesses, hire more attorneys, answer discovery, deal with the inevitable motions practice that will follow, and waste the valuable time and precious resources of this commission dealing with issues that are irrelevant to this docket. And that is what he demands by intervening here. The prejudice is not contingent. It is not hypothetical. It is palpable. And there has been no response to that argument because there is none. By the same token, zero prejudice to him. He's already in FERC, advocating for, quite forcefully, the transmission and wholesale issues that he seeks to force upon this commission. So, with respect, there's no veracity, there's nothing he can say to get around those just salient facts. One more thing I'll bring to your attention. His stated interest, even if he falls back on a retail, is protected the same as any other customer. ORS is sitting right over there. DCA's also intervened. I don't see how you reconcile paragraphs 17 and 35 in the petition at all. I think those interests are fundamentally at odds, and I think you can deny the petition on that basis alone, because under South Carolina annotated regulations 103-825A3, the petition shall clearly set forth the interests. On the one hand, you've got transmission customers saying that, oh, you're trying to foist this rate mitigation plan on us. And then in paragraph 35, you've got a retail customer saying, well, I want to, ensure that that rate mitigation plan comes in. Those are at war with each other. That's not an alternative argument. It's altogether unclear. We're left wondering what is the interest that is being advocated for here. And the reason is there's only a couple sentences in the entire petition about retail customers. That's conclusory. It's insufficient to establish the interest that's protectable under Rule 24 under regulations or case law, and it's insufficient to justify intervention in this proceeding. Now, I next want to touch on standing. He cited Stoney. I was at the court when Stoney came through, okay? It ping-ponged at the Court of Appeals and the Supreme Court quite a lot. That was a divorce case, and it was about the brother of husband being a co-obligor on the loans and needing to go protect that specific interest in property he co-owned. That is not at all what we're dealing with here, and any attempt to rely on that is just simply nonsense, with all due respect. Next, I want to note that that CTCG has disclaimed any reliance on associational standing, but again, in the Preservation Society opinion that they cite in their reply, Justice James walked through the benefits of associational standing if you can meet it. And it really focuses on judicial economy. And we don't have that here. We have 5 individual utilities that within their own petition have differing interests who each want to be involved here. This isn't as a group. They each want to do that. And so judicial economy would not be served. And that's yet another form of prejudice that would inure to the company if you were to allow them to intervene. The attempt to distinguish rate cases is likewise altogether unavailing. Just because he says it doesn't make it so. In fact, I have 2 responses to that. First, rate cases are even broader, right? So you've heard me say that we have these individualized proceedings all along the way, and then it gets put into the pot, and we judge the reasonableness and prudence of it all in a rate case. It's the look back of everything. That's even broader than the narrow issue here, which is a request for approval of a business combination. So I don't understand why the interests there would be narrower than they are here. With respect, they're not. Second, I would say that he's relying on changes in rates. He's saying rates will change as a result of this, and that's his hook to try to get in the door. Well, these aren't rate cases. So how can you say, well, I'm concerned about rising rates, and then go ahead and disclaim rate cases, which are the interests about which he's trying to get in the door? To be clear, no one's changing rates in this proceeding. Y'all know that. We just wrapped up the DEC and DEP rate cases. We're still waiting final orders, but there are directives pending out there. No one's touching rates in this proceeding. So those interests are not sufficient, and they're not protectable to be worthy of intervention here. I'm happy to answer questions as we go along, or I can conclude my presentation and be open to the commission. In sum, I'll say this. The commission's denied intervention, whereas here the petitioner failed to show, quote, any issue over which the commission can grant jurisdictional relief. The commission isn't deciding a retail rate case today, and it lacks jurisdiction over the transmission and wholesale related issues he's trying to force upon it. Because CTCG has already intervened in the FERC, the exclusive jurisdiction, to air its concerns, the commission should deny intervention to avoid tying this already complex proceeding into procedural knots. I will say this. If he feels that his interest is that important, there's another way that's far less intrusive and an effective way. I've written multiple amicus briefs. He could, the North Carolina Utilities Commission has allowed amicus standing. So is the federal district court in the case that I cited, Bishop of Charleston v. McMaster. So the commission could always invite the CTCG to file a petition for leave to file an amicus brief and consider it at that time when proposed orders and briefs come in. So in sum, the petition should be denied, and there are a bunch of factually incorrect things, and I'll go ahead and acknowledge, yes, we made a mistake that first time. I've read about it far more than I cared to, And we owned up to it immediately and said that was not correct. Here's why it's not material. We'd like oral argument. It's not material to this because Greenwood was an afterthought. It's the tail wagging the dog. This petition was called the Carolinas Transmission Customer Group Petition, and that's what they want to talk about. Happy to answer any questions.
Thank you, Mr. Trewick. First, is there anything from ORS?
Nothing, Mr. Chairman.
All right. Are you ready to reply to that?
Yes.
All right. Go ahead, Mr. Spear.
I think I would begin by setting the record straight. I heard him say he a number of times. I'm here on behalf of 5 utility customers that believe strongly that you all need to hear from them, given the fact that they're using this transmission system for 67,000 retail customers located in South Carolina. So this isn't me. This is an interest of 5 parties that have a right to be here. In that monologue, I didn't hear an answer to the question. The question was, how is it that a user, payor, and capitalizer of one of DEC's most valuable assets does not have the right to come in here and inform you all that DEC is dispossessing itself of that asset on bad terms? The response from Duke did not answer that question. That's what gives us status to intervene. Duke's argument, again, as I told you, is that it would be, is that FERC has exclusive jurisdiction over transmission. That's not true. FERC has jurisdiction over transmission rates. CTCG's members are not asking you to interfere with those rates. What we're telling you is that they're going to rise and they're going to end up in the rates of the constituents that all of you represent. I heard nothing about the cases that I cited. I heard nothing about the fact that every single petition that's ever been filed, as far as I know, in a merger proceeding in NCUC and in South Carolina has been approved. It's been granted. And I heard mention of this mistake that they made about the status of Greenwood as being a retail customer. I'd like it noted, I didn't discuss that in my oral argument. We all make mistakes. That's something that they chose to bring up. I heard that this isn't a rate case. We agree with that. This is not a rate case. But everything that you do in this case is 100% going to affect rates. There's no question about that. And I'll conclude. I'm happy to answer any questions.
Thank you, Mr. Speaker. Before there's any reply, does any party online have any comment? Or I think you said you did not at the time, but now that you've heard the initial arguments, is there anything from anyone who's virtual?
No, Chair Powers.
Mr.
And
Hall?
nothing from DCA. Thank you, Chair.
Thank you very much. All right. Would you like to respond?
Just to make 2 points, Mr. Chairman, if I might.
Certainly.
First of all, there's no disposition of assets here from DEC. These are purported DEC customers, and even if you give dispossession its most generous reading, it's DEP going into DEC as the surviving entity. So they don't even have standing to complain about that. Secondly, I keep hearing this consistent history of allowing wholesale customers in, but there's a really big footnote to that and critical context that I continue to hear omitted, and that's that they were unopposed. The ones on which he's relying from the South Carolina Commission were in the context of the SCNG Dominion merger and the VC Summer. I'm not going to insult anyone's intelligence by saying that is not this. I mean, there were hundreds of filings in that docket. I intervened for the speaker in that case. That is not this. This is a limited issue, the proposed business combination. And so to rely on one sentence or conclusory orders to say there's a history of it, I think misses the mark. There's not been any analysis of why it should be there. And I do want to finally correct one misstatement from my friend on the other side. Said that there was good standing in the NCUC order. They said good cause, and it was a one sentence. I wouldn't call that analysis, and we weren't given the opportunity to respond. Don't need to go into that. That'll be litigated in North Carolina, as he alluded to. But those are my only points in reply, and happy to answer any questions from the commission.
Thank you, Mr. Trawick. Are there any commissioner questions at this time? All right. Hearing none, is there anything from any other party? All right, well, gentlemen.
Nothing for Cecilia.
Excuse me?
I'm sorry, Chair Powers. I said nothing else from Cecilia.
Okay, thank you very much, Mr. Witt. Hearing nothing
thank you.
else.
Mr. Chair?
Certainly. Whom?
Mr. Chair?
Yes.
You look to your right. I just want to encourage the parties. I think there's a wing restaurant over there across the street. You might can beat the happy hour traffic. Go out and shake hands and have a happy holidays before everyone gets on the road. I can tell everyone put a lot of work into their presentations today. And even though I'm making a joke, we're going to look at everything that you've said and what you've submitted very, very seriously. So I want to give you credit for the hard work you put into your argument.
Thank you, Mr. Vice Chair, but I would add that when somebody's eating wings, you don't want to shake hands with them. Hearing nothing else, then we are adjourned. Thank you very much.